Afternoon, Brad.
Hello, Eric. How are you?
I'm good. How are you today?
I'm good, thanks.
I know you'll probably bring it up on the presentation, but where does this one put you at today for FinCEN presentations?
138. So, and I think we just topped 10,000 attendees. So,
I was going to say, was guessing you got to be getting close to 10,000.
yes, yeah. The more recently the attendance has been higher because I've done a few more webinars and you do get more folks. And then we just did three in North Dakota that had CE credit, and
Oh.
they scramble to those things when they get CE credit. So looks like we're at about 30 now. Alyssa said she's expecting about 60. So,
Okay.
well, we are at 12:30. Alyssa, would you like us to wait for a couple of minutes or should we go?
You can go ahead and go. I have the recording started, so if anyone needs to view, this beginning part, they'll have no issue doing it.
Excellent. Thank you. Eric, you want
Well,
to kick us off?
sure. Welcome to today's Law for Lunch. My name is Eric Hansen. I'm the president of Dakota Homestead Title Insurance Company and a member of the State Bar of South Dakota's CLE Committee. Before we get started, I'd like to go over a few items so you know how to participate in today's event. First, we start with our PSA on lawyers' concern for lawyers and the hotline to reach out to. Do you or another State Bar member or law student you know have a drug or alcohol problem or struggle with depression or anxiety? Lawyers Concern for Lawyers is a confidential and independent resource for South Dakota lawyers, law students, and their families. Your referral or visit with LCL is strictly confidential and privileged. Call Becky Porter for more information at 605 391 5191. Becky is an LCL member, and your communications with her are likewise confidential and privileged. You can also call 988 to reach mental health professionals or the All One Health EAP at their confidential telephone line of 1 800 451 1834. Press 1 to speak with a counselor. Mental health professionals at both numbers are available 24 hours a day, 7 days a week. Please be aware that that is a new change for the all-in-one health compared to the prior provider. Today's Law for Lunch is on FinCEN Reporting, follow-up questions, which seems like a simple topic that's going to span from there. Today's presentation will last approximately 1 hour. During the presentation, please submit questions by typing into the chat feature in Zoom. I'll also post in there both my email address and Tyson Helder from Old Republics on there. We're both monitoring our emails and the chat for any questions that come up, and we'll pass that along to our speaker. Now I'd like to introduce you to our presenter, Brad Hessian from Old Republic Title Insurance Company. Brad is the Vice President Underwriting Counsel for the North Central Region for Old Republic, where he oversees a team of underwriting attorneys and title agency representatives that cover South Dakota, North Dakota, Minnesota, Iowa, and Wisconsin. Brad is a frequent presenter on a variety of real estate topics to title companies, realtors, lenders, and attorneys. Brad has the distinction of giving the most FinCEN presentations in our area and has agreed to a follow-up presentation that builds on his law firm launch from last September. I'll turn it over at this point to Brad. Thank you so much.
You bet. Thanks very much, Eric. It's interesting. I wonder if there's a trophy for giving the most FinCEN. Maybe I need to buy myself a trophy to put on my desk for the most FinCEN presentations. Um, Eric did mention, though, I have been doing this a lot. I'm happy to be back with you at the South Dakota Bar. I've also spent time with our friends at the North Dakota Bar and the Minnesota Bar. This is my 137th speech, and we are over 10,000 attendees. So I'm hopeful that what we're providing to you is going to be useful. So as Eric mentioned, much of our time today is going to be dedicated to answering questions that we have received from members of the bar about FinCEN. I had a chance to review many of those in the last couple of days and have planned responses for much of those. We are happy to do our best to answer questions that come up tonight. Today, rather. As Eric mentioned, my colleague Tyson Helder is on the line. Tyson is also a member of the South Dakota Bar, and he'll be doing any research that we might need in order to answer your questions as they come up on the fly. Before we get directly to your questions, though, there have been a couple of developments since we spoke last, and I do want to provide those developments to you. The first is, as you likely all know, reporting did begin on March the 1st of 2026. Now, that means that we had to file reports within 30 days of March the 1st, and that was a Sunday. So as a technical matter, March the 2nd was the first day of closings. I have talked to many agents, however, who have filed reports in the first couple of weeks to figure out whether or not what is going to work. In general, the system appears to be working fine. FinCEN is receiving reports. When the information submitted is not complete, the report does a very good job of telling the filer what it is they've missed. And you do have the opportunity to save your report and go back into it in the event the piece of information you missed is something that you need to talk to someone about. I do want to give you just a couple of quick updates on the things that did allow us to get here to start on March the 1st. You'll recall when we talked last September that there was a piece of litigation that was still pending. That case was called FNF versus Besant. It was a case filed by Fidelity National Title Insurance Company in Florida, contending that FinCEN did not have the authority to promulgate these regulations, that it was exceeding its authority, the rules were arbitrary and capricious, and that they violated both the Fourth and the First Amendment. On December the 9th, a magistrate judge did rule in favor of FinCEN, granted summary judgment in favor of FinCEN, finding that it didn't exceed its authority. That decision actually sat for a really long time, and it wasn't until February 20th that the federal district judge in Florida approved that case. The other cases that were pending at the time have since been dismissed. There has been at least one new piece of litigation that I'm aware of. Interestingly, it was filed in Puerto Rico. That case contends on a privacy basis that individuals are not required to give out their private, non-public information to the government. We'll talk about some of the things that FinCEN has said about what they intend to do with this information. The bottom line, though, is that case does not appear to raise any particularly new issues, nor does it appear to raise issues that would keep the regulation from continuing. And as you likely all know, now that the toothpaste is out of the tube, I think a court is going to be reluctant to enjoin the performance of these requirements. And lots of companies, including title insurance agencies, law firms, as well as software providers, have spent a lot of money getting prepared. The other thing that happened after our call is that FinCEN did release its final form. You'll recall that I told you in September that I thought we needed that form about 90 days before everything went live. We received it just before Christmas, so we had 98 days from the time of receipt. FinCEN did provide a testing environment. That testing environment is still open. I saw some of the questions from the Bar Association about how do we learn about this? How do we figure it out? I would encourage you to go and use the testing environment. Tyson, if you could do me a favor and put our bulletin about where it is they can go to the testing environment and where it is they can get information on how to file, I think that will be useful, and it does answer a couple of the questions that I received. So we'll watch for that bulletin. Tyson just messaged me that he will go ahead and put that in the chat for you, so you should consider downloading that. All right. So those are the things that happened related to whether or not we were going to go on March the 1st. And then on February 13th, FinCEN gave me a Valentine gift. They released answers to 107 frequently asked questions. And there were a number of them that were valuable to us, but I can tell you that B5 made my whole week that week. One of the things that I talked to you about in September was that way back in July of 2025, I had the opportunity to be on a call with FinCEN. And we asked FinCEN as relates to vacant land, and we were concerned both about developable lots, but we were also concerned about agricultural land. Uh, they have this great language that says the buyer has to intend to build. And I asked them last July, I said, tell me what intend means. Is it 6 months? Is it 2 years? Is it 5 years? Is it 10 years? Because I can draft an affidavit that says I don't intend to build on it for 2 years, but you need to tell me what it is. And last July, FinCEN said, you know your customers better than we do. Alyssa told me this presentation is being recorded, so I'm not going to tell you what my actual response was. But I was incredulous because we generally don't know what our customers intend to do. And I think it's difficult for you as attorneys to say that you know your client's intent every time it is they are purchasing vacant land. Well, on February 13th, FinCEN changed its tune on this, and the answer to B5 is now that intent to build on vacant land is determined at the date of closing. So what we need to know from a buyer of vacant land, and I think this is particularly valuable in South Dakota with agricultural land, is do they intend to build on that property? Now, I want to remind you that if the homestead is already on that 40-acre parcel, it's residential and it has to be reported. But if you're transferring a 40 that's been tilled for a century, all you need is an affidavit that says they don't intend to build on that parcel. I do want to caution you, though, when it comes to buildable lots. So here's what I would say, first of all. There are developers who never intend to build on lots, right? They buy a 20-acre parcel, they lay the water and sewer, they pave the road, they put up street lights, maybe they put in sidewalks, and then all they do is sell those vacant lots to builders who are going to build on them. You may and you should accept an affidavit, and title agents will accept an affidavit from a developer who says they do not intend to build. You should be much more cautious, and title agents are going to be much more cautious about builders who say they don't intend to build on vacant lots. And let me give you an example. You can have a builder who owns 5 lots in a subdivision, and all of a sudden, someone who bought a private lot decides to sell one at a fire sale price. And so the builder doesn't have anyone to build for on that lot, but decides to purchase it because it's inexpensive. And then they'll say to us, I don't intend to build on that because I got these other 5 to build on first. I would not accept that affidavit. And here's why. That is inventory for their business. The same way that a car dealer says, I don't intend to sell the green car because we don't sell green cars very often. I intend to sell the black ones and the white ones and the silver ones. If the customer comes along who wants the green car, they're going to sell the inventory. If a buyer comes along who wants that new lot because it's cheaper or because they like that it's at the end of the cul-de-sac or the beginning of the cul-de-sac, whatever they like about it, the builder is going to sell that lot to them. So where a builder treats lots as inventory, you should be suspicious and concerned about accepting an affidavit that says they do not intend to build. We don't have any track record from FinCEN about whether or not they intend to discipline parties providing reports in the event we misread this issue of intent. So we're going to be careful. We don't want to be disciplined. I don't think you want to be disciplined either. So we should be cautious about that. Eric, you want to say something?
Yeah, I'd say the other thing I would just add is that since FinCEN falls under the Treasury Department along with the IRS, they do have access internally to how that builder is treating that lot on their tax return. And while it's not known that they would cross-consult with each other, it certainly is possible that on a FinCEN investigation, they would go and see that they were showing that as inventory for a builder as further proof that even though they didn't put a house up right away, that there was intention to build that at a later point. So you should have used common sense to know that, you couldn't rely upon the affidavit.
Excellent. Thank you. There were a number of other FAQs that were valuable to us. That was the most valuable one. The other one, though, I want to talk with you about real quickly is H2. One of the things that we were concerned about is when we receive money from another closing. And the example I have here on the slide is a title agent. But let's say, for instance, that in your law office, you handled a closing for the sale of a parcel of agricultural property, and then you wired proceeds into the title company because your seller on that parcel of ag was now buying a parcel of recreational property. The way we read the rules before these FAQs is we were going to have to report your law firm's bank, routing number, account number, and the holder of that account. FinCEN has now told us in these frequently asked questions that we do not need to report the bank information where the funds are coming from another closing. So we'll still have to report $250,000 received as a result of a closing, but we don't have to give up your bank information. That's really valuable to us. I also think that that can be extrapolated, that we don't have to give that up for the parties who send us the earnest money. So if earnest money is being held by your law firm, when you send us that earnest money, I don't think that has to be reported. I think what we've really been told here is that where it's from another participant professional in the real estate transaction, that we're not required to make those disclosures. A number of other things that I want to tell you about these FAQs, even though I didn't make a note here. One of the things I think is going to help us a lot in South Dakota is FinCEN has told us that Native American tribes do qualify for the government reporting exemption. That was not clear from the prior rule. And if you read the statute they linked to, Native American tribes were not listed as one of the government entities. Now we know from the frequently asked question answers that we can rely upon Native American tribes serving as exempt entities because they're a government entity. I really would encourage you, and Tyson, why don't you also put our bulletin on the frequently asked questions into the comments? I would encourage you, if you have time, to just spend a few minutes looking at those 107 answers. Because more than anything, it provides clarification. What I feel FinCEN has done is said, hey, everybody, take a deep breath. We're going to make this reasonably easy in the start. That doesn't mean that they won't change some of these answers as they start getting reports from us and as the FBI and DEA start digging into the value of these reports. But at least for now, I think FinCEN has said we can relax a little bit on some of the things that were making us anxious. So, Eric, that is what I had as sort of preface remarks. So, I'm sorry, I do have a couple of other things I wanted to talk with you about. I do think law firms should be making a plan. And based on the questions that many of you sent, it certainly seems like you agree with me, trying to figure out how it is you're going to do these reports. And we do have some guidance, or at least some suggestions for you on that. I do note, by the way, that Tyson did put that second bulletin in the chat, so you can feel free to grab that if you'd like. I think some of the things you should be thinking about if you're handling a private transaction is when the buyer and seller need to be told about these requirements. When I speak to realtors, and I've spoken to hundreds and hundreds of them, I say, look, the seller needs to know at the time of listing. Because actually, right before I got on this call, I had an email from someone who said, do you have language that a seller can put in their listing that says they don't want to participate in FinCEN? We are going to have sellers, and I think I gave you this example in September, but we're going to have sellers who don't want to participate. Both my kids live outside the United States, and they're beneficiaries of the trust that owns my condo. So if I were to sell for cash to an entity or trust, I would have to disclose my kids' passport numbers and UK visa numbers that allow them to live outside the country. I'm not doing that. And I'm not alone. There are going to be other people who are going to have those concerns. And so I do think it's important to get that to the seller right away. In terms of the buyer, ideally before they have drafted a purchase agreement, so that they understand both what they have to do, but also the position they're putting the seller in, because they are putting the seller in an unusual position if they meet those three criteria: cash transaction, residential real estate where the buyer is an entity or trust. When we met in September, I also showed you, I'm sorry, Eric, did you want to say something?
Nope, I think that's good. The only thing I would just add is just making sure your buyers understand the cost as well for that choice that goes in with it. Each office that's doing the reporting will be different, but there is a cost. No one has announced that they're doing this for free or as a goodwill service for what goes on. So there is an additional cost to the transaction when you're choosing to use an entity or a trust on a cash purchase as defined by the rule.
So FinCEN estimated this was going to cost our industry about $1 billion in the first year. We don't have $1 billion worth of profits that we can use to supplement this. What I would say, and I think Eric appropriately sort of refrained from what the costs may be, but because I don't work directly in the South Dakota market, I can tell you most of what I've heard is somewhere between $300 and $400. Agents are settling on kind of 300 to 350 is generally what I'm hearing. I'm allowed to say that. Eric's not, because he has agencies in the market. So the other thing that we talked about in September is I showed you the Wisconsin disclosure as well as the California addendum. States have been frantic trying to get these documents together. North Dakota did an addendum that should be available by the 1st of April. Eric, though, has been actively working on these, either an addendum or other disclosures in South Dakota. Eric, can you give us an update on that, please?
Sure. I've included in the chat, and it'll be available afterwards too, the current language that comes from the South Dakota Realtor Association and the South Dakota Land Title Association. We make use of about 3 sentences as an inclusion in most Realtor Association purchase agreements that just discloses that there is this potential reporting requirement for FinCEN, and if it does apply, or you change it to apply, that an addendum will need to be done. And that addendum goes into more detail about when you have to provide information, as well as how the costs are allocated. The non-branded version of those, because I helped draft them, so I'm feeling free to share with the State Bar for what goes on, are included in the chat that goes on and will be posted afterwards. Please feel free to make use of that. The South Dakota Real Estate Commission has been approached as well for their publicly available forms. For what they have, they're still taking under advisement as to whether or not they can include a change based on some of their precedent for when they add or adjust what those agreements say. To deal with that situation, we drafted a closing compliance agreement that is very similar to what the addendum has. You may see that if you didn't include a FinCEN addendum on a purchase agreement and there's not a realtor involved to add one, that the title company who's doing the reporting may add that. Feel free, if your office does closings, to make use of that as well as an attorney in the state closing transaction, so that you have something signed by the party saying that they understand and agree to what you're requiring. Because as stressed throughout the spot, we're not closing transactions unless we have all information. So having something in writing that establishes that that is the standard is really important for anyone who practices with real estate.
Excellent. Thank you. Another thing I would say to you is there were lots of concerns about what was going to happen to this private information. Specifically, was it going to be subject to Freedom of Information Act requests? Would it be shared among other government departments? As part of the FAQ answers that came out on February 13th, FinCEN did say that the information filed in these reports is not subject to FOIA. I think those of us who are familiar with this are not surprised by that. I mean, the government typically does not make social security numbers and dates of birth and home addresses subject to FOIA requests, but there was a lot of anxiety around that. And so FinCEN has made that clear. If your office, though, decides to do your own filing, you are obligated under the rules to retain that information for a period of 5 years. I got to tell you, that terrifies me. We're already worried about protecting data security, and now we're getting all sorts of non-public information that we have to retain on our servers for 5 years. So I'm going to talk with you a little bit later about whether or not you should be doing this in-house or you should think about contracting with an outside provider. But if you decide to do this in-house, that's one of the things you have to think about, is how are we going to protect this data for a period of 5 years? And then the last thing I want to say before we get to your questions specifically is we do have to report where the money came from. I told you we were given that exception that we don't have to do it now for money that comes from other title companies or from other closings. There's lots of value in that to us. My biggest concern here is this obligation to report items that are paid outside of closing. And here's why. They're paid outside of closing, which means we don't see it, right? When you close a closing in your office, the money's going to come into you that you'll distribute to the parties. So you'll be able to see where it came from. If it came by cashier's check, remember, you can't use the cashier's check. You have to figure out where the buyer got the money to pay for the cashier's check. You need bank, routing number, account number, and holder of that account. But we never see, for instance, the earnest money. From a title insurance perspective, that goes to the realtor's account because they use it to offset their commission. So where your office is handling reporting, if there's anything paid outside of closing, you need to make sure you're gathering the information about that bank account. Earnest money is sort of the obvious one, but there are lots of other things that can be paid outside of closing. The buyer decides they want to give $500 cash for the riding lawnmower. Just don't put that in the purchase agreement, and then we don't have to worry about it. But if it's in the purchase agreement, I got to worry about it. If the purchase agreement says that the seller is going to replace the well, because when the buyer buys the house, they want to put in a second bathroom that needs a larger well, and it has to be done before closing because after closing, the ground's going to be frozen and the well can't go in. Now I need to know where the money came from to pay for the well, even if it was paid directly to the contractor who did the work. Anything paid outside of closing that benefits the seller of the property needs to be reported. And it's those POC items that really have me terrified. I'm very worried about us finding that information.
I would also just add that there's a variety of POC items that pop up at times when you have like a VA loan where they need to pay it outside of closing and not disclose that it was paid outside of closing. I'm not saying that what was done is right, but we do see it happen in terms of it. That's one that what you put in your purchase agreement and what you're detailing that goes on. Don't do it at the office. Please figure out a spot where we're not involved and we don't know about it. But if it's on the purchase agreement and we know about it, then we need to be addressing it because you're the reporting party and you have a responsibility to report all funds involved with the closing.
Well, I would argue that if you amend it out to avoid reporting, we still have a problem. So it's best not to amend it out.
Don't break the law.
Yes. Yeah. And while we're talking about that related to private information and such, the other thing I would say is FinCEN has determined that the attorney-client privilege does not attach. So you cannot argue that I don't have to provide this information because I received it under the guise of attorney-client privilege. My personal opinion, and we're recording this and I'm still going to say it out loud, I don't think the federal government can require attorneys to waive the attorney-client privilege, but I'm not suing FinCEN to determine whether or not that's actually true. So until someone brings that litigation, we have to behave as though the attorney-client privilege does not attach to this information. All right. So now I'm going to get to the questions. Eric sent me a summary of the questions he received, and I have summarized them in an even shorter version in order to make them fit on the slides. So if I missed something, if you don't feel like I fully asked your question, please either pop that in the chat or if they're able, you can unmute yourself and we're happy to talk with you directly. There are only about 50 of us on the call, so I'm confident we're not going to talk over everyone. So the first question we got is, are transactions for no consideration reportable? And the answer to that is absolutely yes, right? So, in the geographic targeting orders where we've had to report for the last decade, there was always a basement under which we didn't have to report. So for instance, in Texas, you didn't have to report a transaction under $30,000, but that created a loophole where the criminal could just buy 10 properties at $250,000 and now be laundering that same $2.5 million without having to report. So it did not go to $1. It went to $0. Transactions for no consideration are reportable. So if I own a property in my own name and I'm transferring it to an LLC where I'm the sole member, it's still a reportable transaction. Now, if Eric and I are members, it's reportable as well. But the fact that you are the sole, people keep saying to me, well, it's the same membership as the other LLCs. It doesn't matter. A transfer from an individual to an entity where they are the sole member is still a reportable transaction. We're going to talk about this more in trusts, but there's really only one exception. And the exception is where you have an individual or individuals who own property in their own name, and they transfer it to a revocable trust where the same people are trustees and the revocable trust is for estate planning purposes. That is exempt from reporting. But I want you to understand how narrow that is. And I'm particularly concerned about attorneys here because you're the ones who are going to be held responsible if that trust is not for estate planning purposes. We in title insurance are nervous. Do we have to determine whether or not it's for estate planning purposes? If you drafted it and it ends up not being for estate planning purposes, the discipline is likely going to be wrought on the law firm that made the filing claiming it was exempt when in fact it wasn't. And if I didn't say this in September, I want to make sure I say it here. What the government is particularly concerned about are passive trusts, also known as Illinois land trusts. Those are trusts that take the power away from the trustee and they vest it in the beneficiary. The government's concerned about that because the criminals were hiding themselves as the beneficiary in those trusts. So if you have a trust that's for estate planning purposes, but it has any sort of passive component to it, the government is not going to find that is for estate planning purposes. And remember, I specifically said the exception is only for revocable trusts. So if you have created an irrevocable trust for someone who owns property in their own name and they are now the trustee, irrevocable trusts are always reportable. So the exception is very narrow. There is an exception also for entities, limited liability companies that are drafted for estate planning purposes. I know that's possible. I haven't seen many. The fact is, folks use trusts when they're doing estate planning, but there is an exemption for limited liability companies that also are drafted for estate planning purposes. Okay, so that's the first question. Are transactions for no consideration reportable? The answer is yes. Second, what can attorneys do if we don't want to handle reporting? And the asker of this question, by the way, did a great job of saying, I don't want to break the law. I just don't want to be responsible. So what do attorneys do if they don't want to handle reporting? Can they hire someone else to do the reports? And the answer is yes. And there are a number of ways that can be done. First, you can make arrangements with your title agent. Now, I have not heard about title agents in South Dakota that are actively marketing to handle this directly for attorneys. There are title agents in North Dakota that have decided to do that as part of their marketing plan. I will tell you the fee is going to be higher than that standard $300 to $350 fee because they feel like they're taking on more liability and they're not collecting a premium. So I do expect the fee is going to be north of $500 if you have a title agency handle that for you specifically. But you can hire a title agent to handle the filing for you. The other thing you can do is you can contract with an outside provider. You know, one of the things that's interesting to me is over the last year as I've watched this evolve, it was my expectation that there were going to be lots and lots and lots of providers that would do this. And there are a number of providers who are providing various components, but there's a company out there called Real Estate Report, known as RER. They have kind of cornered the market. I'm surprised at how quickly RER was able to consolidate the market. Now, there are significant discounts on RER's services for title agents. However, law firms are allowed to contract with RER. My sense is that you're looking at probably $180 to $250 per transaction if you contract with RER. Title agents are getting a much steeper discount, much less expensive than that, but because of their volume. We can provide, if folks would like it, the contact information for RER where you could reach out to them. My sense from agents so far is they've done a very good job, and they will also do everything. So they actually have a portal where they will create the forms that the parties need to fill out. The parties fill it out right in their portal, and then they do the filing directly from the portal. So the attorney's involvement is going to be nominal. The only time I think the attorney will be contacted is if there's some sort of anomaly in the way they're filling the form out. I like to remind folks that these sort of providers are designed to catch 80 to 90% of all transactions. There's going to be 10, 15, 20% that are so weird that we're going to have to file them ourselves. That's okay, right? But that is one option for you. The other thing I would say is I have heard attorneys who work with who are trust and estates attorneys say, I am no longer transferring the property to the trust because I'm too worried about having to file. So instead, what I'm going to do is a transfer on death deed. I'll create the trust, and then we'll create a transfer on death deed that allows us to designate that trust as the recipient upon death. If you do that, there's no reporting. TODs are exempt because TODs are not a transfer, and a designation in a TOD or a will or a trust, a designation to an entity in a TOD is exempt from reporting at the time it transfers. So I think there are a number of things you can do. You can work with your local title agent. You can use an outside reporter. And I noticed that Tyson just put RER's website in the chat. So you're welcome to click on that and get information that you need about RER. Or where your practice is primarily related to trusts and estates, you consider using TODs, because those are going to be exempt from reporting at all stages. At the time you record the TOD and at the time the property is transferred to the end recipient.
One thing I'll just add for RER or for the title company is it doesn't change the fact that if you're dealing with your client, that you may still have to provide information or help them track down what needs to be filled in for what goes with it. The one downside is even though like RER is great for asking the questions to have the client put it in, it can't make your client know things that they should know for their entity or for their trust. So they may still be coming back to you as their attorney or to their tax advisor to gather that information.
So the next question we received is, I am preparing a deed that is going to be used for a real estate closing. Do I need to confirm with the settlement agent that they are going to be completing any FinCEN reporting requirements prior to or when I email the deed? So that's going to depend on what the job is of everybody in the transaction. You'll recall in September, I showed you the waterfall, where reporting starts and where reporting goes. There are 7 entities that are obligated to report. The thing about that waterfall, though, is that the buck stops with the one at the highest point in the waterfall. So the first reporting entity is the settlement agent under the settlement statement. And the second reporting entity is the party that prepared the settlement statement. So even if there's not a settlement agent because the bank is closing their own loan, if the title agency closed or it drafted the settlement statement, the title agency fits those first 2 pieces. So if you as the attorney draft the deed, you're number 7 in that waterfall. Because someone is above you, they are obligated. You don't have to worry that they're not going to do it and it flows down to you. If they don't do it, they're the one that's in trouble. You're not the one that's in trouble. So as long as someone is above you in that waterfall, you don't have to worry about it. If you are worried, communicate with them. Hey, by drafting this deed, I am potentially putting myself in the FinCEN reporting waterfall. Are you intending to report on this transaction? Because if I were you, I would then decline to draft the deed if they say no. So I think it's important to just have communication where you're drafting a deed for a title company or for someone else in some other type of transaction. Make sure someone is above you who's obligated to report, and then you're going to be fine. Similarly, we got a question that says, when I prepare a deed and notarize their signature, but I do not take the deed to the courthouse to record, do I need to be worried about FinCEN reporting? So drafting the deed is number 7 in the waterfall. It's the last one. So there are 6 people ahead of you who would have an obligation. But if, for instance, you are helping a private client who is just transferring hunting land from themselves to an LLC, then drafting the deed likely makes you the top person because there's no closing, there's no title insurance policy that's issued, there are no funds that are being distributed. And if you give it to the client to record themselves, they can't be held responsible for reporting. So it's you at the drafting level. If, however, you prepare and notarize that deed, but you send it over to the title company who handled the transaction, now they're at the top. So it really depends what's happening. The way this question is asked is like, hey, I'm just drafting a deed for a client. It's the only thing that's happening in this transaction. Then yes, even if you don't take it in for recording, you are responsible for doing the reporting. I will tell you, this is why title agents are not doing courtesy drafting anymore. We used to have people call us all the time and say, hey, you closed my house 5 years ago. I want to put it in a trust now. Will you prepare the deed? We used to do that, $150. Now, if we do it, we put ourselves in the waterfall. So it is certainly something you should be concerned about. I will tell you that if this is part of your regular practice and you're giving up a reasonable amount of fees, just add in the fee for doing the recording, right? So now instead of it being a $250 fee for drafting a deed, now it's a $750 fee because we also have to do the reporting. There's nothing wrong with that at all. You just need to make sure you're collecting sufficient fees to do it. And then the follow-up question to that is, what if I just draft it, but the client gets it notarized elsewhere? Listing yourself as the drafter puts you in the waterfall. So if you're just helping a client, there's no other transaction going on, just by doing the drafting, you've put yourself in the waterfall. And in that instance, you're almost certainly the one who's going to have to report, unless for some reason they have a cousin who works at the title agency and they say, will you record this for me? Then by the title agency recording it, they're higher in the waterfall and they would be obligated to report. But I can tell you that most owners of title agencies know that, and we are not doing courtesy recordings anymore. All right, looks like we don't have any other questions yet. Oh, let's see.
Oh, just got one.
Eric, how about if I move on while you digest that question?
Move on while I take a look through it, okay?
That sounds great. Okay, so the next question was, how does one sign up for reporting with FinCEN? So that first attachment that Tyson posted in the chat, that is a bulletin that we sent out to our agents in South Dakota that tells you where to go to register. It tells you how you can go in and use the testing portal. So if you are concerned about doing your own reporting, please take that document out of and it's listed as MNB 25-005. Pull that document out of the chat and use that document to help you get the information you need on where to sign up for reporting. Again, if you're interested in using an external reporter, then we've also provided that information for the FinCEN Real Estate Report, where you can sign up for them. So you can either do it yourself through FinCEN, or you can use an outside entity. By the way, FinCEN Real Estate Report is not the only reporting entity. They do appear to have kind of cornered the market, but you should do your own research if you're concerned about using another entity. The next question, is there a way to create multiple profiles for a reporting entity? Not only is there a way, it's encouraged. So you should not be creating one profile for your law firm and everybody goes in and uses that one. Instead, FinCEN wants to know who every individual person is who has the authority to go in and file on behalf of the entity. So you should be using, again, that form we provided you to take a look at whether or not, or how it is you can go in and create those individual profiles. Eric, is there anything I need to respond to right away?
So for discussions of settlement agreements, typically as part of, it could be a probate, a divorce proceeding, or just as part of a civil lawsuit, is there a requirement that as a part of drafting the deed that transfers the property as part of that settlement for FinCEN reporting. And what I would say, and I'll type it in the chat to go with, if it's anything tied to a court order as part of a lawsuit that goes in with it, there is an exemption piece that deals with it if the order specifically deals with and says this is what's supposed to happen with the property. Something that's done outside of court, maybe like a resolution that doesn't go in and doesn't get included as part of the dismissal that goes with it because you reached a stipulation, is more questionable. So anything you're doing tied to litigation, try to make sure that the final court order references that the real estate transfer is a part of it to make sure you fit that court order exemption. Feel free to add on to that, Brad.
Yeah, so the rule says that it's a court directed or court guided transfer of real estate. And so I agree with Eric. I would want, if I were going to decide I don't have to file, I would want the order to specifically say that the deed needs to be done in order to transfer the property. And like all of the exemptions from reporting, I would view them very narrowly. So if there's any question about whether or not the order grants the authority, I would file the report. You will never get penalized for filing too many reports, but you will get penalized for not filing a report. Okay, let's see. Are there resources for practitioners on FinCEN reporting? So kinda. Here's the thing. Because this affects the title insurance industry, the vast majority of resources are directed at how title insurance agents handle this. However, the education provided for title insurance agents does have value for practitioners. The American Land Title Association, also known as ALTA, actually has a boot camp that's coming up sometime in the next couple of weeks. You do not have to be a member of the American Land Title Association to sign up for that boot camp. I believe it takes place over 2 days, and I think it's 2 to 3 hours of education each day. 3
hours each day. Yep.
So I would highly encourage you, if you feel like you're going to be doing 5 to 10 of these a month, I would highly encourage you to attend that boot camp. But there is not a resource specifically for law firms that I'm aware of. We did a little bit of research. We haven't been able to find anything that specifically targets law firms. That doesn't mean, though, that the title insurance education isn't valuable to you. And I think that's what I would encourage you to do. I have also recorded a number of webinars, and I've done podcasts and things that do have lots of additional information. Tyson actually just put the link to register for the Alta Bootcamp in the chat. So it is there if you would like to take a look at that. We can also provide you with recordings I have done. But you've all heard that. So I'm not sure how useful that would be, but we certainly can make those available to you. What forms should we use to gather the information from the parties? If you're doing this yourself, you should use the American Land Title Association forms. They have created fillable forms. They're terrific. The first page of the form does a really nice job with standard form language, telling the parties why this information is being gathered, what it's going to be used for, how FinCEN is going to use it. And then the forms they have to fill out over the course of the next 9 pages are also really well explained. The other thing I would say is, for the benefit of law firms, that the Alta form has a terrific certification on page 9 that requires indemnification of your firm if the person filling it out has lied or done anything else that causes you harm or damages as a result of those investigations. So I would strongly, strongly encourage you to look at those Alta forms. We do have copies of those, and we're able to provide them. They can also be gathered from the Alta website. So is a 1031 exchange reportable? This question was much broader, but I wanted to boil it down to those 5 words, because 1031 exchanges are super simple. Here's the deal. The qualified intermediary is exempt from reporting. The QI never has to report. So just take them out of the equation. And now look at the transaction and ask yourself, is there a loan? And if there's a loan, then figure out if that lender is an anti-money laundering reporter. But if you're doing a 1031 exchange where the buyer is getting $250,000, they're paying $500,000 though for the exchanged property, so they're bringing another $250,000 in cash. That's cash. The fact that half of it came from a 1031 exchange does not change the equation. So just think of the whole thing as cash. Take the qualified intermediary out and now look at it and figure out whether or not there's a loan on that transaction. So in the same way, if they get $250,000 out of their 1031, but they're buying a $500,000 property, so they're taking out a $250,000 loan from US Bank, that's an anti-money laundering reporter, and now we don't have to report because we have an anti-money laundering reporter with an attorney. Eric, any question there I need to deal with, or you're handling those as they come?
Just follow up about if you're just preparing the settlement agreement, not the deed, do you have to worry about reporting? And the answer to that is no. Whoever's drafting the deed that goes with the settlement agreement needs to worry about reporting. But just because you're involved drafting some other document, not the deed, doesn't obligate you to be a reporting party as part of that transaction, unless you were doing the closing, which again is a highly odd set of facts that go in, because you're not usually doing a closing as part of the settlement agreement.
Yeah, I would agree. Again, the best way to boil that down is it is the execution of a deed that triggers reporting, right? So if you are not involved in the execution of a deed, you do not have to worry about whether or not you are reporting. If you've drafted a deed that gets executed, now you're in the waterfall and you got to figure out whether or not there's anyone above you in the waterfall. If you've submitted the deed for recording, now you're in the waterfall and you have to figure out if there's anyone above you in the waterfall. But if all you've done is drafted a settlement agreement, there's nothing about that that is the execution of a deed, so you don't have to worry about the potential for reporting.
And Hannah, for your follow-up question that you just posted on there, the spot for the last spot on the waterfall for an attorney is the attorney who drafted the deed, not the attorney who represented the party who on their own drafted the deed. So if your client chooses to use a print off of online deed and you didn't advise or guide them with it, your client is responsible for figuring out their FinCEN reporting for what goes along with it. It doesn't put that back on you as their attorney, because if you're not involved with the preparation of the deed, your involvement as their attorney does not matter or make you liable for FinCEN reporting.
That's right, and the client is actually going to be exempt because that.
Yep.
No one in that transaction whose job it is to be exempt. I don't recommend that you try and funnel your transactions that way. But if it happens in that instance, that is going to be, there is no reporting required. So the next set of questions were related to contract for deed. And let me tell you this. There we go. It looks like I'm briefly. Okay. Here's the issue with contracts for deed. A report needs to be filed for a contract for deed. The preference is that that report be filed when the contract for deed is entered into. So after March the 1st of 2026, when parties enter into a contract, there we go. Eric, it looks like you're moving, so maybe I can see you.
Yep, I can hear you better now. Cut. So just to back up,
you're talking.
The question about...
There we go.
Eric, I'm just going to test my audio. Can you hear me okay, or is this on Brad's computer specifically?
I can hear you just fine, Tyson. Are you hearing me all right?
Yeah.
I thought he's talked too much when it goes to it.
Sure. Well, Brad.
There we go. Can you hear me now? It looks like I'm back.
You're good, Brad.
Okay, terrific. So the issue with a contract for deed is that we need one report, right? And for any contract for deed that was entered into after March the 1st of 2026, we're going to report on that one at the time it was entered into. Now, if we have one that was entered into after March the 1st of 2026, when there is a deed in satisfaction of it 5 years later, as long as we know a report was made, we do not need to make a report. So if, for instance, title agency A handles the closing of the entry into the contract for deed, 5 years later, that same title agency handles the satisfaction. They know they already filed, so they don't have to worry about it. If title agency B is handling the satisfaction, they should investigate to figure out whether or not a report was made at the time the contract for deed was entered into. So if, for instance, ABC law firm is handling the satisfaction, and I understand that often doesn't happen at a title agency. So ABC law firm is handling the satisfaction. They need to be confident that the report was filed at the time the land contract was entered into. If you can't confirm that, you should file again. There is no penalty for filing a second time, but we don't want to get dinged for not filing, for having it not be filed. Where you are handling the satisfaction of a contract for deed that was never recorded, that means it was never reported, right? If you have an unrecorded contract for deed that you're now satisfying and you're recording the deed in satisfaction, you are going to have to file a report for that. Where I think we're going to have to be very careful for the next several years is a contract for deed that was entered into prior. Did we freeze again? Nope, we're still okay? Okay, good. Contract for deed that was entered into prior to March the 1st of 2026. We know that contract for deed was not reported because there was no reporting requirement prior to March the 1st of 2026. So when we satisfy it, we are now going to have to do the reporting. What FinCEN has been clear on is that one report is required on every contract for deed. Our job is to confirm that one report was made. I will tell you, for contracts for deed entered into after March the 1st, I feel pretty confident that we're going to be able to figure that out. Because what we're going to say is, hey, do you know if a report was filed? Because if it wasn't, we're going to have to charge you $400. And they're going to go, I think I was charged $400. Let me see if I can find my closing statement from when we entered into this. They'll find it, and the fee for FinCEN reporting will be there. That's a clear indicator that the reporting was done, and now we're not able to, or now we're not required to report. So I do want you to be careful about contracts for deed. One report has to be filed. So if you know it was entered into prior to March the 1st of 2026, we're going to have to file a report upon satisfaction. Eric, do you have anything else to say on that? It's kind of a complicated issue.
The one thing I'll just add is that for contract for deeds after March 1st, for what goes along with it, just be aware in terms of how you'd go about your contract for deed business with you and your clients. We're well aware that some attorneys are involved all the way through, that they prepare the initial contract for deed and other documents that go with it. We also know that there's some clients out there who draft their own contract for deeds in terms of that they, are used to the process. So they and their neighbor have a, handwritten or shortly typed up version. Just make sure if you're touching a contract for deed, you know where it came from and what you could rely upon.
So, Eric, we have about 4 minutes left, but this is the last slide of questions that we got. So I think we'll be able to work through this. I already provided the exemption for trust. Just remember, it's a very narrow exemption. It's only where an individual already holds in their own name and they transfer it to a revocable trust for estate planning purposes. There is no other exemption related to trusts. Then we got this very interesting. Go ahead. What'd you say?
Even if my trust qualifies, if I transfer from Eric Hansen to the Hansen Family Living Trust myself, just because that same trust does qualify, when the Hansen Family Trust buys new property and it never goes through me individually first, it doesn't qualify as exempt.
That's right. Once it is a purchaser, there's no exemption. It's only when transferring property you already own into your trust for estate planning purposes. So, yes. So we got this very interesting question that Tyson and I spent some time thinking about this morning. Is there reporting for Medicaid trusts, SLTA, IDGT, credit shelter trusts, etc., where the grantor transferor is not the beneficiary of the trust? The answer to that is yes. I think the best example, and forgive me because you didn't use this one, and I'm going to pick something else, but what we see a lot are folks who take title in their IRA because their individual retirement account is using the money and they're essentially using it as an investment for their IRA. Doesn't matter who the beneficiary or the grantor or the transferor is. If a trust of any type is entering into title, then that trust is going to have to report. So all of these trusts, and frankly, Tyson and I were like, I wonder what a credit shelter trust is. I could guess, but I didn't do the research. But these are all going to have reporting requirements. Okay, next. Does the transfer of LLC membership interest trigger reporting? I've gotten this question a lot, and the answer is no, because there is no deed, right? It is the execution of a deed that triggers reporting. So as long as there is not a deed that transfers the LLC membership interest, and there would be no reason to do that, so as long as there is not a deed that transfers the LLC membership interest, then there is no reporting requirement. I will tell you, I think this is how folks are going to get around reporting in many ways, right? Your LLC already owns. How about if I just buy your LLC membership interest? Now, it's going to have to be an LLC that solely owns one asset, but I do think this is a way that folks may get around reporting sometimes. Last couple of questions. We're at 129, so I think we're going to be okay. When an entity is owned by another entity or a trust, how much information needs to be collected and reported? You got to get to a human being. So LLC, owned by an LLC, owned by an LLC, owned by a trust where the trustees and beneficiaries are humans, that's where you report. And you don't need to gather any information about those three LLCs at the top. You can skip over them. You go right to the trustee and beneficiaries of the trust. So all you've got to do is get to humans, right? Now, there are a couple of times that you can't get to humans. One example is if you have an REO company that is holding property in trust as a result of a foreclosure, that's okay. We can explain that the trust is a corporate entity, but the reporting person then is the person who signs. So we still get to a human, and the human is the person who gives a signature. And you'll see that when you look at the Alta form, Alta buyer collection form on page 5, you check the box if you are the signatory. So whoever signs on behalf of that trust, even though the trustee is not a human being, the signatory is the one who has to disclose. And then let's see, if an LLC is owned by a trust, can do the trustees report? The answer is yes. You go till you find a human being. There's got to be a human who signs at some point. So either it's the human being who owns or it's the human being who signs. It is 1:31. Are there any additional questions we need to answer?
There's one in the chat regarding contract for deeds when you're preparing the initial contract itself. What goes along with it, but not the deed and fulfillment. Do you have a reporting requirement? So I just kind of put in the clarification. If you're preparing the short form contract for deed, the memorandum of contract for deed, something that's being recorded, because again, the recording of a document is the trigger event, then yes, if you drafted the document that's recorded, you are a reporting person. If it's
the person listed as the drafter, it's the same as the drafter on a deed. The person listed as the drafter on the contract for deed is going to be number 7 in that waterfall. Yes. Alyssa, anything else you need?
Nope, I'll be ending the recording in just a moment and we'll get this uploaded to our State Bar website. There will be a type form questionnaire that will go out after this. So keep an eye out for that. And please, we would love your input on this amazing presentation. Yes.
Yeah,
Thank you.
just don't say don't ever have Brad back again, please. Just, that's the only one that hurts my feelings. Hey, thanks everybody. Thanks so much for having me. It's always great to see you.
Thank you so much, Brad. And then for the members of the State Bar, everything that Brad and Tyson put in the chat, I have downloaded those items as it has gone along. Listen, I'll send you a copy of them, as well as probably a page that has the links to those websites too. That way that can be posted along with the video when that goes out. So
is there any
please
reason
feel
you need the PDF of the PowerPoint?
I don't
I mean,
think
it's in the
so.
video, so I don't think you.
Right. I think it's
If
just
somebody
the
wants
video,
it,
it's
let me
okay.
know. But it really is just the questions that came from you all.
Yep.
Okay.
Well, thank you again so much, Brad. Thank Tyson for the help with it. We greatly appreciate your help.
Okay. Thank you. Bye now.
Have a great day, everybody.